All right, well, welcome. This is installment 2 of the California Ballot Initiative's overview. So I'm Jennifer Walsh. I'm Dean of the College of Liberal Arts and Sciences, and I'm also a professor of political science and have done this now for the last 8 years. So thanks for coming back. You know, the pros and cons of having a video session is that when people know that they can sit at home and watch it in their jammies, it means that we have fewer people in the room. But sometimes that's okay because then you all get to ask questions and people at home don't. So there's your incentive for coming. All right, so just kind of a quick disclosure. We've got some serious stuff on the agenda for today. So for those of you who are delicate of ears and don't like squeamish things, you have been forewarned. So you have had your trigger warning for the day. All right, so let's dive in. All right, so a couple of reminders about where we started last time with an overview of the state budget. We don't have as many items on the agenda for today that cover budget, but I thought I'd include it just as a reference point. 39% of our state budget is mandated to be spent on K through 12 education, so that's part of our constitutional requirement. And then healthcare comes in second. That's more of a discretionary item. Higher ed and prisons are third and fourth. So as we talk about different measures and in the cost savings or the cost reductions, that might be something to keep in mind. In terms of our revenue, a couple of things that we'll be looking at today includes excise tax revenue. And so you can see that we have a precedent for that with cigarette tax and other types of product-related taxes. So that is just there for your reference. And then in terms of where we start today, we're at Prop 60. And Prop 60 is the adult film condom requirement. This is taking what Los Angeles voters enacted a few years ago and expanding it to all statewide activity. So right now, just so you know, there is a requirement in the labor laws that say anytime a worker or employee is exposed to potentially harmful agents or bodily fluids that could have pathogens, the workers are required to have protective gear. And so this would include condoms. But it hasn't been specified directly in the law until Los Angeles County enacted Measure B a few years ago, and this will potentially expand it statewide. As you might imagine, the goal is to reduce STIs because, you know, and that could include anything from AIDS to HIV, now to Zika. We know that Zika is a transmitted virus that can come through bodily contact, including sexual fluids. So that might be something to think about beyond just the traditional STI, sexually transmitted infections definition. On top of that, there's a whole licensing requirement for producers. So if you are in the adult film business, right now you don't have to apply to the state to film in the state of California, but if this is enacted, you would have to pay a licensing fee, and you would have to let the state know within 10 days of filming what you're filming, where you're filming, and then also certify under risk of perjury that you have provided training programs for all your employees, that you have posted signs at the filming site indicating that condoms are supposed to be worn. You also have to provide condoms. You have to provide STI testing and cover it yourself. Right now, employees or actors in the film business have to demonstrate that they are STI free, but they have to cover those costs themselves. So this would shift the cost structure onto the producers and anyone who has a financial interest in the film. There's also strengthened accountability pieces in that if the compliance is not reached, that anyone who has a financial interest in the film could potentially be fined or sued in court. So on the yes side, those in favor of this measure would point to the concern about STIs as being really the driving mechanism behind this, that this is such a potential grave threat to people exposed to bodily fluids that this creates a requirement for employers to protect them. On top of that, you have the issue of who gets to pay for this, and they view it as a workplace hazard that the employer ought to pay for. So it would protect employees from having to bear those costs themselves. So that's the other big pro position. probably less of a driving concern is the cost savings for the healthcare industry in California, because right now the rate of infection is not all that high among adult film actors. Nonetheless, there's always the potential, and if those diseases are caught, they're often costly ones. Hepatitis and AIDS are very expensive to treat, and it would potentially then generate some cost savings if we could eliminate or reduce the number of infections. As you might expect, you've got the AIDS Foundation, you've got other healthcare organizations saying that they support this measure, and then Peace and Freedom Party as being the one political party that's gone on record at the state level to say they support this as well. On the opposed side, the people against this measure say that it's too broadly crafted and there's too many loopholes. And the one thing that seems to be a real concern, and I went back and traced it in the code, and it is there, is that if a complaint is filed against the film producer with the state, there's going to be a state agency. In the literature, they're talking about a porn czar at the state level, so I don't know who's going to get that job, but apparently it'll be available. And so if you are, apparently exposed to an adult film and you don't see a condom being used, that the presumption is that they're out of compliance. And so a complaint would be filed with the state agency, and the state would have to then do a fact-finding mission to see if they were out of compliance or if there actually was evidence of compliance. If the state declines to find fault, so if they say nope, no harm, no foul, then it creates a private right of action. So any Californian, so all 38 million of us, could potentially sue in court for some sort of damages because it was not obvious that a condom was used in an adult film. And they think that's really going to create a nightmare for trial courts, that it's going to create all sorts of nuisance lawsuits and really doesn't get to the heart of the matter, which is trying to reduce STIs and protect workers. So that's the big concern, is it's going to really be a boondoggle for attorneys, who are taking these nuisance lawsuits, but it could clog courts, it could increase litigation costs for the state, who would have to defend some of these suits if they are the ones saying that there was no fault that they found, and that could cost taxpayers a lot of money over the long term. So because of that, those concerns, Democratic Party and Republican Party have both signaled their opposition, as well as a number of groups that you might other think would normally support, and that includes LGBT groups and AIDS Project LA. So it may be a little bit more complicated. Since there's fewer ones, we have a few minutes for questions over each one. Any particular questions on this one? I should also point out, because it's on the slide, that they do talk about the adult industry potentially leaving California because of the requirement, and they might go to neighboring states or somewhere else. I don't know how much of a concern that is to you, the voter, but it would potentially result in a loss of taxpayer dollars, because it's especially in the San Fernando Valley, it's, believe it or not, one of the chief industries of that part of Los Angeles County. Now, having said that, after Prop B was enacted, we didn't see, as far as I know, I couldn't find anything in the literature, widespread flight of those industries. So there has been some measure of compliance, but the accountability piece isn't as strong as potentially it could be if this proposition were to pass. So that's another consideration. It could be. The driving force is a film producer, and he had a financial stake in the piece that's the most controversial. He would get all the lawsuits that average Californians could sue. So his motivation, if that piece is rejected and it's not approved, his motivation to bring another initiative forward may not be as strong, because right now he has a pretty solid financial interest in seeing this particular version go through. I don't know that there's any, perhaps an anti-film agency or group might bring it forward, but I don't know that there's any one interest group that would want to put that much money into getting the signatures and getting it on the ballot. Okay, so let's move on, and if you have other questions, we might have time at the end to ask. Now, I've seen a ton of ads about Prop 61. You probably have too. So out of all of the initiatives, this is one that's generated, I think now, the most dollars, both on the pro and the con side. Pharmaceutical companies are pushing the no piece, and we'll talk a little bit about that in a moment. But basically what this proposition would do, it would require the state to negotiate the same rates with drug company providers as is currently available to the VA, so the Veterans Administration at the federal level. So the federal government has a provision where the VA can negotiate special rates for drugs for the 9 million patients that are in the VA system. What this would do is obligate the state of California to enter into a contract that is equal to or less than the VA amount. But there's a couple of caveats. First of all, it only applies to drugs paid for by the public employee system or directly by the state. So that would be a fee-for-service Medi-Cal patient or any public employee unions that are enrolled in a state-sponsored health care plan. One of the concerns that we'll see in a moment is that the proponent of this initiative who put together the signatures and crafted much of the language exempted his own HMO. So HMO patients who Medi-Cal patients who enrolled in a managed care system, an HMO, would be exempted. So they could have drugs that are negotiated at higher rates or they wouldn't be tied to the same provision. So that's why 75% of current Medi-Cal patients who are treated through a managed care environment would not have to fall under this mechanism. So really it's about 15% of the state's residents that would be impacted by Prop 61, and then there's concern about what that might do, and we'll see that in a moment, to the availability of drugs. But that's basically what Prop 61 is telling the state of California, you have to enter into the same arrangements that the VA currently is able to do in order to drive down drug costs, because the VA can negotiate a very low rate. So on the yes side, cost savings is the driving force. The VA can negotiate a good rate, and the state of California, while it can lump all of their negotiations together and kind of do an economy of scale offering for drug companies, it doesn't necessarily have the same teeth as a federal VA system, and so therefore it has not the same leverage in terms of drug purchases. So they think this would increase the leverage of the state and allow for a more favorable price point for drug companies to sell to us. And that would reduce taxpayer dollars, because right now the state of California is paying for all of these drugs. It's because it's public employees with state-sponsored health plans, as well as fee-for-service Medi-Cal patients that have costs covered directly by the state. So it's coming right out of the general operating fund. That's why I put back in the expenditures. Healthcare is the second largest expenditure that we have, and so they're hoping that this will generate some savings. You might have seen Bernie Sanders featured in some of these ads. He's a leading proponent of Prop 61. And then we also have Peace and Freedom Party, Green Party, a few county Democratic organizations, AARP, and a few other civic groups lumped in there for good measure. On the no side, there's concern that we don't know how much savings, if any, it would generate. So even the Legislative Analyst's Office did not put down anything in terms of projected savings. And the concern is this: we don't know how drug companies are going to respond. They're under no legal obligation to sell to California at the same rate that they sell to the VA, right? So just because we can't buy at a higher rate doesn't mean that they're going to sell. It takes two in the marketplace to complete a transaction. So they might say, thanks, but no thanks. We're not going to sell you at the same rate as the VA. And that would put state of California a bit of a bind, because in order to receive matching funds for Medi-Cal patients from the federal level, because they pay a significant portion of our healthcare costs and matching grants, we have to offer the full range of drugs available through the FDA, or the vast majority. So if an FDA drug is approved, the Medicare and Medi-Cal requirements are that we have to make that available to patients. We can't shortchange patients in a public system by narrowing the amount or the type of drugs available. So if the drug companies don't want to sell us at the lower rate, we might have to pay a higher rate anyway in order to stay eligible for matching federal funds. The second thing that could happen is that VA rates might increase, right? So the drug companies would say, that's fine, we want California's purchasing power because it's a big player in the market, And we'll just raise rates for everyone. They don't have to have a certain rate negotiated in fixed amounts with the VA. So veterans organizations are concerned that this will then lead to pressure to raise VA rates overall by the drug companies. It could also mean that the drug companies say, well, the drugs that we make available to VA patients, we're not going to make available to you. We'll give you other formularies or other versions that maybe your healthcare provider doesn't think is as effective. And that could limit the number of remedies available to patients across the state. So that's another potential outcome. And because we don't know how drug companies are going to respond, it's uncertain as to whether any savings will be realized at all. We all know that pharmaceutical companies have extensive R&D costs, and they've also been in the news for price gouging. So there's great anxiety, I think, about what might happen. And as a result, we see some marshaled opposition. The Republican Party, the Libertarian Party, a bunch of drug companies, as you might expect, but then also civic organizations and patient care groups as well. Okay, questions? Drug companies would say we already negotiate really good rates with the state of California because they pool all of their patients into one pot for the sake of drug negotiations, and they would say we already have an economy of scale built in that other states don't necessarily have to their advantage because of the sheer volume of patients that we have. But you know, that's the extent of what I've heard them say in terms of a response. Okay, let's move on, and if we have more questions, we might have time at the end. So way I've done this in your packet, I've put the two competing death penalty positions back to back, so we're going to go a little bit out of chronological order. We'll do 62 and then 66, because it's easier just to do a direct comparison while we're on the same topic. So a little bit of background information on California's death row population. Since 1978, which is when most states reenacted the death penalty for those that chose to do that, Supreme Court declared it unconstitutional in the early 1970s and then declared it, reauthorized it if certain precautions were instituted. In 1976, California voters reauthorized it via constitutional amendment initiative in 1978. So we've had it back on the books since 1978. We have currently 749 condemned inmates. And I'll show you a slide that gives you a little bit of a breakdown. But we don't regularly execute inmates in California. So since 1978, only 13 have been put to death in the state. 2 inmates were put to death in other states because they also qualified for the death penalty there. So that means most people on death row don't die of artificial means. They die of natural causes because they're there for a very long time. So as you can see here, in terms of the breakdown, there are 3 people on death row in their 80s, 27 in their 70s, 138 in their 60s, and then, of course, the proportions get bigger the younger you go. But it's because of that, then this initiative becomes relevant. So going back to the previous slide here for just a second, this comes up for consideration by voters every few years. So the last time repeal of the death penalty was on the ballot was Prop 34 in 2012. It was rejected by 52% to 48%, a very narrow margin. In the past, it's been overwhelmingly supported by voters, usually around 2/3 to 3/4. This support has been steadily slipping. 30 states have the death penalty across the U.S., and that too is starting to slowly decline. I should also point out, in case you're not familiar with how death row works, only certain types of murders will qualify. So it's not your garden variety murders that will put you on death row. It's ones that involve multiple victims, particularly vulnerable victims like elderly and children, police officers in the line of duty who are executed or killed by offenders, anything that involves mayhem, torture, extreme pain. You have cases where victims beg to save their life and the perpetrator kills them anyway, things like that can be documented. That is all presented in a special penalty phase that happens after guilt or innocence is determined. So if the offender is declared guilty and the prosecutor has indicated early on that they are seeking the death penalty, that is considered by the same jury in a separate penalty phase. So after there's a cooling off period of a couple of weeks, then the jury will reconvene and decide what the penalty will be. If the judge doesn't agree with the jury's determination because the evidence isn't compelling enough to justify those special circumstances, there's a protection built in where the judge can override the jury's recommendation of death. It can't go the other way. So the jury can't recommend life without parole and then have the judge intervene and say, nope, the inmate's condemned. So there's a safeguard there for the offender. Okay, Supreme Court has also weighed in on both method of execution and eligibility for execution. So no minors can be executed, even if they're adults when the execution order is handed down. If they committed the crime when they were under 18, they're ineligible. They're also ineligible if there are mental illness history or a low IQ. That's been a recent development as well. Okay, so on the pro side, the argument might be having life without parole as kind of the ultimate sentence allows victims' families to move on. They don't have to wait, in limbo, wondering when an offender might come up for execution, because the process can often be very emotional. There's lots of stays for execution filed at the last minute. It puts victims' families in kind of a precarious state in terms of their emotional well-being, and so this would kind of provide immediate closure. Once that initial conviction is handed down, life without parole becomes a done deal, and they don't have to worry about parole ever coming up because they're ineligible. It's also a cost savings. Death row is really expensive to maintain. These are special care inmates who are isolated from the rest of the maximum security population. They have, kind of special requirements in terms of appeals and access to attorneys, and so this would also cause some savings on that sense. And then ultimately it becomes a matter of practicality in addition to your philosophical leanings. If we're not executing inmates anyway, why bother having this special population that we have to pay for? So you've got a variety of proponents here, some faith organizations like LA Archdiocese Jose Gomez, Archbishop there, other Catholic and Episcopal priests who have argued on the side of life, probably since the very beginning. We also have President Carter and all parties except the Republican Party who have maintained the opposite position. So on the opposed side, there's a philosophical argument that says death is only really appropriate for 1% to 2% of murders, and it ought to be retained because there needs to be some punishment that goes beyond life without parole for those crimes that are truly heinous. And so justice demands kind of the ultimate punishment for a small group of offenders. They also point out that life without parole can be very costly in and of itself because as an inmate ages, they incur greater health care costs, and the state is obligated to provide all health care needs, including organ transplants and other potentially costly remedies for aging inmates. And we have a constitutional duty as a state to provide all care. So they're going to argue, as we'll see in a moment, rather than ending the death penalty, let's amend it, let's fix it, and make it more efficient. Now, if both Prop 62 and Prop 66 pass, and voters say yes to both, which would be a little interesting because one says repeal and the other says make it faster. But if both say yes, then the one that has the most votes will prevail. Okay? That's how that will work. So, Prop 66, you can almost take the opposing and supporting arguments and flip them. The time length is a concern to those who like the death penalty but are worried about its lack of efficiency. So the average inmate for the 13 inmates that we've executed, they spent almost 18 years on death row before their date of execution was set. Part of that has to do with our lengthy appeals process. So in 1996, the federal government passed the Anti-Terrorism and Effective Death Penalty Act, that's AEDPA. And the intent was to speed up some of the lengthy federal appeals. And to many, that's why Texas is executing offenders much more readily than California is because they were relieved by some of the federal appeals burden, and they don't have a corollary concern at the state level. California, though, has a pretty well-established appeal process. That includes both direct appeals in case the inmate believes that there's an error that happened during the course of a trial, and then appeals called habeas corpus appeals, which allege that something illegal happened that requires an immediate review, such as wrong jury instructions or incompetent counsel. So both types of appeals could potentially add to the delays because it requires a hearing by the court to see if the offender is worthy of additional review, or if the case is worthy of additional review. So as you can see, part of the delay stems from the lack of attorneys who've been appointed to represent death row inmates. Right now, that responsibility lies with the Supreme Court. That was given to the court by the Judicial Council, which is a group made up of judges here in the state of California. And this proposition would expand that to include a Court of Appeals rosters, try to increase the number of attorneys who are eligible and certified by the courts to represent death row inmates. On top of that, what they're hoping with this proposition is to also shift some of the appeals away from the top Supreme Court down to the original trial court, where the judge who was originally assigned to the case would be asked to review unless there's a petition that's approved to move it to somewhere else. And that, they think, will help to reduce some of the logjam that's happening in the Supreme Court. Now, one thing you should be aware of is that when the U.S. Supreme Court reauthorized the use of the death penalty in 1976, they said that all inmates must have an immediate appellate review because of concerns about racial and ethnic bias, misuse of evidence, other jury emotional inflammation, because sometimes death penalty cases are really, really awful, and juries tend to respond emotionally to those cases even after a cooling off period. So right now, those appeals are still not part of this conversation. Those are required by the U.S. Supreme Court. So the minute someone is handed a death penalty sentence, it goes immediately to the state Supreme Court for review. And assuming that the state Supreme Court approves the sentence as being appropriate for the case, then the other appeals become eligible, both direct appeals alleging constitutional abnormalities or some sort of jury instruction or lack of competent counsel. So right now, 80% of inmates on death row have additional appeals beyond that automatic appeal. So everyone on death row has had clearance by the state Supreme Court as being an appropriate sentence, and now they're filing additional appeals. So Prop 66 would limit that period of additional appeal to 5 years in order to speed things up. All right, so on the yes side, these proponents are saying this is a way to fix the death penalty, to really make it an effective final punishment for the worst of the worst. It would bring closure to families. It would save taxpayer dollars because we wouldn't have inmates spending that much time on death row like they do now. They do point out, as I traced it down in the code myself, the 5-year time lane could be expanded if the defendant is able to raise substantive issues of innocence. Because that's always a concern when you have the death penalty on the books, is that potentially you could have an inmate with factual innocence executed, and that's an argument we see on the opposed side. Typically, from talking with folks who prosecuted death penalty cases, those factual issues tend to come up within a short period of time, especially now that DNA testing has become more routine. In the past, it was a little bit different, but now that it's become more routine, it's not quite as lengthy in order to discover new evidence. But that is an opponent's argument that, you know, what happens if substantive issues come up 6 years after the case was closed and the person has already been executed? What then? So that's showing up in both the pro and the con side, the 5-year timeline issue with substantive innocence. So again, kind of looking at the same parties involved. This time we see the Republican Party supporting the amend proposition. Most district attorneys, and for disclosure, that includes one of our adjuncts who's also the Riverside District Attorney, Mike Hestron. He's signed on as being a supporter of Prop 66. But most urban counties have as well. So Los Angeles County, San Diego County, Sacramento County, Orange County, San Bernardino County. and law enforcement groups. Again, some of the concerns is that you've got potentially too short of an appeal process. It could also be very costly because you have to hire a bunch of attorneys to handle these cases in a short period of time. And then the concern about potentially executing someone who's innocent, and you have the same parties who were supporting Prop 62 opposing Prop 66. So questions on both of these propositions? Yeah, so 62 would ban the death penalty and 66 would accelerate it. So I don't know, it might. So the ad campaigns I've seen have been, you know, yes on 66, no on 62, or yes on 62, no on 66. So I think the supporters of each initiative are trying to get that message in the minds of the voters that you really shouldn't vote yes on both. There's a cognitive dissonance if you do. But, you know, voters are independent thinkers too. Yes. Correct. Now that's just the state appeals timeline. Of course, then if there's substantive issues they want to raise at the federal level, there's a potential way for them to file in federal court, although it's been more difficult since the federal law was changed in 1996. So it's not as generous of an option as it used to be. But yes, it would start immediately for those on death row. There is, right now the threshold is 50%. So inmates work and up to 50% can be deducted from their checks and redirected to victims' families for restitution. So Prop 62 would increase that to 60%. Prop 66 would increase it to 70%. Now, inmates are not making big bucks, so the extra 10% is probably not going to make a difference. No. What would happen is that the time would start now, right? So or as soon as this is approved, that 5-year clock would begin, assuming they can all get attorneys appointed, right? That's often the log jam. So it would start from the moment you have an attorney appointed, and then they have 5 years to work on your appeals and raise new issues that are worthy of consideration.
Like a wash.
Yeah, so what you would have is short-term costs increase, and the proponents, at least of 66, would say then it would have long-term costs decrease. So once those backlog of appeals get cleared out, it would keep kind of the cycle of appeals from continuing infinity, you know, because that's what happens right now is that if your appeal's denied on this claim, then you raise another one, then you raise another one, you raise another one, you raise another one, with the hopes of avoiding execution forever. Well, not forever, but, you know, for, you know, until natural death occurs. So the thought is that they would shorten that appeals process and they would have a backlog to clean up, and that would be some short-term cost increases. But if you are able to administer the ultimate penalty before inmates start incurring long-term health costs, that it ultimately would result in some savings, right? Because most other states don't have a death row the size of ours, right? We have 749 inmates, and that's a lot of folks to keep track of in that special population. Okay, let's move on, and then if we've got time, we'll come back. So Prop 63, we're going back now in chronological order. Firearms, ammunition, or numerical order, sorry. Firearms, ammunition sales. And the goal of this is to try to direct all ammunition sales through licensed dealers. So this complements 9 other bills that the legislature put through and passed this past year to really address gun violence and some of the kind of aftermath of the San Bernardino terrorist attacks. The thought was there aren't any licensing requirements for people to buy ammunition, and there's no background check to buy ammunition. So this would require people to go to a licensed dealer who would pay a fee to the state for the privilege of selling ammunition. You would have to pay if you were a gun owner and you wanted to buy ammunition. You'd have to pay for a background check and license to buy. You'd have to have approval from the state, or at least not be on their bad list to buy ammunition. And it also limits then the amount of ammunition you can buy. Already high capacity clips were sunsetted out a few years ago, but there was a grandfather provision for people who already had legal permission to own high capacity firearms from when the law was different. And this would eliminate that grandfathered provision, and it would kind of limit the number of a magazine to 10 rounds or less, which is the maximum right now. It also would create a felony status for all gun thefts, because right now in California law, if you steal a gun that costs less than $950, it's considered a misdemeanor, and you might not do any jail time for that, because we don't really punish misdemeanors any longer with jail time. You might get a ticket to appear before a judge and then get a fine, but it's very unlikely you would do jail time just for that. So this would require all gun thefts, regardless of how expensive the gun is, to be treated as a felony offense. And licensed ammo or gun dealers would have to report any thefts directly to the state. So on the pro side, they're hoping that this will reduce gun violence by only selling ammunition to people who've been vetted and approved by the state. It also gets out of the business of selling ammunition on the internet and other out-of-state, off-site sales. They think it will help law enforcement track down gun theft rings and other criminal networks because of the automatic mandatory reporting requirement. And they're hoping, too, that it will deter folks who want to purchase and store up large quantities of ammunition. On the opposed side, and so the proponents are Democratic Party, who passed a similar measure in the legislature. Brown vetoed it because he knew this was going to be on the ballot, and he said, since voters are going to weigh in, it would, I'm going to withhold judgment. So a very similar measure was passed, but he vetoed it because of this initiative had already qualified for the ballot. So the Democratic Party supports it. A lot of mayors and local city councils support it, and a variety of medical associations because of the response of gun violence, and a few public employee union groups. On the no side, you have the general sentiment that bad guys don't follow the law, right? So whether or not you require them to get a license or a background check, they're already bad guys. They're not going to follow that, right? They've got other ways of getting weapons and ammunition, and really this amounts to harassment of legal gun owners who are already following the law, already in compliance. They're not the perpetrators of gun violence. So that has led to some concerns that this would be a diversion of law enforcement resources, that police would be spending more time tracking down really infractionable offenses because so-and-so didn't buy from a licensed dealer or the license is out of date, rather than spending their time and energy tracking down the real bad guys. So that's kind of the sentiment of the no side. All of these minor infractions would have to be processed by the courts. I think that could also be a burden on the system. And the opponents are both the Republican Party and Libertarian Party, also Peace and Freedom Party, just about every law enforcement association, and most of the state's urban district attorneys. Yeah, I think it's a way to deter firearm dealers from selling large capacity magazines and other prohibited ammo, because they'd have to be licensed and audited by the state, which currently they're not. I mean, well, sure, for hunting, but also for self-defense. I mean, I'm trying to think of the average gun user. We're not talking about usually the 50 chambers, but they're, kind of round cylinder-shaped magazines that have 50 plus rounds. But 10 rounds sounds like a lot, but isn't necessarily when you're
target shooting.
Yeah, you go through them pretty quickly. Yeah. Prop 64, marijuana legalization. This basically says that anyone 21 and older can purchase marijuana for recreational use, and you can also grow it. This authorizes the growth of up to 6 plants per person, both in-house or outside, in actually like a greenhouse, so it has to be contained somewhat. It also creates an excise tax and a retail tax. So you've got both a tax on the flowers as well as the leaves, and also a 15% retail tax on any marijuana product. And there's a big, hefty section of government code that is proposed to deal with all the regulation aspects of this product, which previously was viewed as a dangerous product by the state and continues to be viewed as a dangerous product by the federal government. So it's a very interesting constitutional question that becomes immediately raised But the feds have basically declined to prosecute any marijuana possession cases for recreational use, and so it's almost a null issue. But according to the federal government, it's still a prohibited narcotic, and so that's always, you don't know who's going to win an election in November and what that might mean. And anyway, just kind of a interesting turn of events. It also regulates how the product is advertised, marketed, and sold. And it allows local governments to create some additional regulations on top of that. Okay. So if you're interested to know where the tax revenue would go, it would not go in the general fund. So it's identified for certain amounts for different funds. One would be to address job placement issues for people who are coming from communities where drug abuse has been a historic problem. There's a $10 million allocation to study the effects of recreational marijuana use on probably both public safety as well as individual health. Right now, there's no specific DUI standards for driving while impaired with marijuana use. And that's part because we haven't had a need for it. So recreational marijuana use right now is illegal. So no amount is allowed in your system while operating in a vehicle. This would authorize the CHP to test and create a standard for impairment that would then be accepted by the courts. And right now, the generic impairment standard would be if the officer believes that you're impaired, you shouldn't be driving a motor vehicle, then you can be arrested for DUI. But it's not as certain in the courts, and so there's question about whether those arrests and convictions would stand if there's not a specific impairment amount identified like there is for alcohol or prescription drug use for certain popular narcotics. It also creates some funds for youth programs, substance abuse programs, and then also some environmental effects that come with cultivating plants. Okay, on the yes side, people are already using it. Medical marijuana use is already a popular option. This would recreationalize it for everyone. It would allow it to be licensed, regulated, taxed. It would be limited right now to adults over the age of 21, and there would still be some limits on how much possession you could have at any one time. So again, the goal is for personal use, not for selling. If you're not a licensed seller, you shouldn't be in the business of selling, and therefore there are some amounts identified with both the plants as well as the leaves and the concentrated purified form. It's supported by the Democratic Party, ACLU, California Nurses Association, NAACP, and a bunch of other groups. On the no side, there's concern about what this will do to traffic fatalities. The Automobile Association commissioned a study a couple of years ago that showed that traffic fatalities doubled in the state of Washington where marijuana was allowed for recreational use. And so there's concern that that might also happen in California, especially if there are no specific DUI limits identified right now. There's also concern about organized crime activity. Law enforcement has said that in Colorado, which legalized it a few years ago, it actually increased drug trafficking rings, not reduced them as it hoped. And so there's no prohibition right now in this version that would allow governments to ban offenders with drug trafficking convictions from entering the legal marijuana business. So they think that that's going to be exploited by the criminal community. There's always concern about impact on low-income minority communities since they are already plagued with drug use and abuse. There was a concern about TV advertising noted, but I put an asterisk there. We can't do anything about TV advertising. That's an FCC, it's a federal thing, so I'm not sure why they raised it. It's not really relevant here. It's opposed by the Republican Party and Libertarian Party, which I thought was interesting because Libertarians usually are in favor of free consumption. Various city councils, law enforcement agencies are also urging a no vote on legal marijuana. Questions?
It's a safety issue.
Yeah, so employers could still ban drug use, and that could include legal marijuana as well as alcohol. So that would still be an option. The other issue to consider is that because the federal government has put it on one of their most dangerous drug lists, and it's been there for some time. We have very few medical studies on the effects of marijuana use, both short-term and long-term. So the lack of research has many health professionals concerned because there's anecdotal evidence of impairment. There's been some just recent studies done in states that have legalized it or used it for medical marijuana purposes, but we just don't know the long-term effects on developing brains, established adult brains, how that will impair other organs and other functioning, because the federal government hasn't allowed medical research to really develop on this issue. So it's a bit of an unknown. Okay, we have 1.5 minutes. If you guys will hang with me, I'll go fast. I've got the two plastic bag related items grouped together here. So let me just unpack this for you quickly. Prop 65 says if there's a statewide ban on plastic bags, and if there is a corollary fee for paper bags, that any fee is diverted into environmental funds only, that the stores cannot keep the funds, right? That's all Prop 65 says, is if at some point there's a fee that's established, stores cannot keep the fee, they have to divert it to environmental funds. What Prop 67 says is we want a statewide ban on plastic bags. 40% of California residents already live in areas where there's a ban on plastic bags. And this basically ratifies a legislative bill that was worked out earlier in 2014 that allowed stores to charge for paper bags up to 10 cents per bag, and keep it to offset their costs. Because retailers came back and said, for a paper bag, a sturdy paper bag, it costs us about 15 cents per bag. We can't absorb that much cost. And so in areas that had existing bans, and then in the legislative version that we're being asked to vote on, they allow up to 10% to be 10 cents to be charged to help stores recover the costs. If Prop 65 passes, stores can't keep that money. They have to divert it into an environmental fund to help combat the effects of plastic bags on wildlife. So the pro and con side is that the plastic bag companies don't want a statewide ban. They would prefer you to still have the option of plastic or paper, and they're trying to get retailers to vote no on the statewide ban for Prop 67, that's represented by Prop 67, by telling them they'll have to eat the costs of paper if you want a paper bag, because right now they can charge you in those areas that have the ban in place. So in terms of the environmental effects of plastic bags, there is a little bit of research that we can see. Only 3 to 5% of plastic bags are actually recycled. Coastal communities were one of the first to ban plastic bags because they saw them blowing into the ocean and being consumed by wildlife. Birds and sea life in particular tend to eat them, and it kills them. So that was a concern, and then other communities have found it to be a littering nuisance. On the plus side, the plastic bags are disposable. They're meant to be disposable. So if you have, E. coli in your beef, or you have salmonella on your chicken package, and you put it in a reusable bag and you don't wash it, potentially that could increase your foodborne illnesses. So plastic bags are convenient, and they help to preserve some aspects of health for the community. They also point out that reusable bags and paper bags are costlier to manufacture, and they also generate more energy to make, and so therefore greenhouse gases can increase as well. So like before, if you vote yes on both, then whichever proposition gets the most votes will be the one to prevail. It would go into, I forget the name, it's like Environmental and Wildlife Protection Fund. So it would not go into the general state coffers. We're talking about Prop 65 here. Prop 67 would stay with the grocers because they need to cover their costs. But at 65, it would go into the special fund. And it said it would go for grants to help the environment. And that's all it specifies. So but it's not part of the general fund. And the produce bags, the real thin ones, or the thin bags to cover your meat, that's not part of this initiative at all, either one. So we're talking about the single-use white plastic bags that you often take your groceries home in. All right, well, thank you. We're a little over time, but thanks for coming, and happy voting. Yay.